Mike Beck with Park One Property Management. Now, here's the way this thing's going to work. First, Johnny's going to tell us about what he observes about property management from the seat of being a judge. And he's going to be talking for about 10 minutes on this. And then he's going to go back and we're going to ask some questions. I've got a couple of questions I want to ask, and then we're have to the panel, and then we're going to open it up to the group. So with that, I would like for Johnny, if you'd come forward, and it's all yours.
Well, good morning. If I had to leave a few minutes early, I have evictions on Tuesday morning, so I'll have to leave. And I was looking at name tags, and I think I saw some on the tenant side that's on being evicted this morning. So you might want to check. At first blush, I would like to explain to you that you spend money filing in our court or the other 4 courts in Collin County. You take your time to come to the court to file. Your $82 in Collin County. You come back to court at the day of the hearing, and what happens somewhere in between, landlords, managers, property managers, pro se owners will come before me with a room full of folks, and I'll call their name, and I said, "What do we do for you today?" I want them out. Okay? How do you want them out? Well, they owe me money. The tenant is standing to my right, thinking, I'm not going anywhere. These people don't have a clue what they're doing. Last Thursday, I had 51 evictions. Only 3 substitute trustee sales, and those normally go much smoother because the individuals, the agents, the attorneys presenting the protocol, they understand what their job is. But with apartment owners, some leasing managers, some agents, and pro se owners, they don't have a clue. So we have many things passed out this morning, but I have a guideline to presenting plaintiffs, landlords complain at trial. And let me tell you, if you walk before a judge prepared, as long as a dog didn't eat your homework on the way to school or to court.
What does that look like? That handout?
It's right here. It's on the front table. I didn't want to co-mingle with the others, so this is really legal high-powered stuff here. Anyway, they are up here, and let me just share with you some information what needs to be done. If I stand over here, let me see this microphone. I cannot be tethered to a microphone in the podium. When you come before the court, some things that you need to have done. Describe the land, the premises, the possession which is claimed by the plaintiff. In other words, what piece of property are we discussing? For example, you must have the property 1234 Main Street, anywhere USA, zip code. That does a number of things. That fixes that in the precinct in which you're filing suit. And the lawsuit may only be filed in the precinct in which the property resides. So you must have that. For example, you have an example of, it may be Route 1, Box 78, Barrow Crossing Drive, Dublin, Texas. You have a post office box, you have a physical address, you have the county and the state. So there's some flexibility, but it must be secure. In other words, now, state the facts why you are entitled to the possession. Cite the property code 24094. They haven't paid rent. 2403. Anything in property code 2400 is where you get your right to evict these folks. But if you don't prove it up in court, I cannot pull it out of you. In other words, I know what you're trying to say and why you're there, but I cannot do it. And then, most importantly, on the eviction form, you have to state one statutory law why you're evicting these folks: breach of lease, failure to pay rent, or any other all the numbers that we have why you may evict a person from the residence. Now, If you have a signed lease, and trust me, not every piece of property, as you all know, has a signed lease. If you do not have a signed lease, then you can file for lack of payment, but to file for breach of lease is very, very difficult unless you have a signed lease. And then on the notice to vacate, you must present the notice to vacate if you have it with you. Notice to vacate you must tell the court how it was delivered. First class mail, hand, certified mail, or posted inside the front door. One of those four elements must be met before I can go forward in the eviction suit. Now, if you hand it to somebody that's 16 years old or older, I would suggest that you write the person's name down, the date and time, and to document that. We have more trouble with notice to vacate than any other area. So let's do a little bit of role playing. I come before the court and I say, Judge, I'm here to evict these folks. And there's this pregnant pause. The tenant is standing to my right and they're waiting. Okay, for back rent. How much rent? 2 months. How much is that? Let me say, I gave them a discount in the first month, they didn't pay that. And in the second month, they were only there 3 days because the smoke alarm system was not working. 2 months. How much is that? Well, I don't know. Then you start picking up paper. And the tenant all the time is thinking, okay. So typically I will turn to the tenant after you presented protocol and you've done the good job, but just like a drill sergeant. Just go right down and check off your list. I turn to the tenant and I say, do you have any evidence or testimony? And the evidence is, I've paid the rent and here's my documentation. Of course, if you accept rent in cash, you must provide a receipt. If you accept rent on money order, typically what the tenant will bring in is a stub that says $300. And what does that apply to? I don't know. You know, I'm not a lie detector test. So, if you've filed suit and go before the judge and just do this punch list I've given you, when we have attorneys from the substitute trustee cells, and they will come up and they do it so professionally. Occasionally, if we have room for pro se litigants and some other folks that don't know, I will ask the attorney representing the substitute trustee cell to introduce protocol loud, so everybody in the room can hear it. So understand, when you come before me, I cannot read your mind. If you stutter, if you stumble, if you fail to produce evidence, you're given a great opportunity to lose a case, because the law is very explicit as what you must present to us. Now, in that, let me ask you, talk about two things. A possession bond. Does anybody know what a possession bond is? Okay, that's good. Forget it. A possession bond happens somewhere in Harris County with a population of 4.2 million people or higher. It says that you can file a possession bond at the time of the eviction, and if you pay the possession bond, which is set by the judge, then you may take immediate possession of the bond, of the property. Problem is, there's a hearing. There's scheduling. After the first day, before the 8th day, on the possession bond, you may save 1 day. You may save 1 day by filing possession bond. You don't do that to our staff. It is so difficult. So throw the possession bond away, but it is available. Now, you file the writ. The eviction is successful. You file a writ of possession. The tenant comes in and you say, the times are hard. I have $200 I can pay, or $300, or maybe in the contract it said, on the lease it said I would paint every 3rd month for a part of my rent. I'll paint another apartment for you. What happens? You create another contract. It's called accord of satisfaction. So once you reach an accord of satisfaction, you have substituted one contract for another contract.